Now, there's been mixed reaction to President Cyril Ramaphosa's decision to finally sign the Electoral Amendment Bill into law. Many say it is inherently stacked against independent candidates. They're accusing Parliament of creating an act that protects the interest of political parties. Let's unpack this further. We're joined by Daryl Swanepoel. He is the CEO of the Inclusive Society Institute. Mr. Swanepoel, thank you very much for your time here on eNCA. Of course, looking at the fact that the bill that has been signed into law now looks at provinces as constituencies. This is going to make it very difficult for a person such as myself who wants to probably, if I wanted to form part of the pool of people that could be elected next year, it'll make it very difficult for me to stand against a person such as Bangaza Lesufi, for instance.
Good afternoon. Firstly, thank you very much for the invitation to be with you. Yes, it is going to be very difficult for an independent candidate to be elected. But let me start off by saying that at least we are happy that the law has now been signed, in that we have a basis to work from now, and we're no longer in as to what the president's going to do in terms of signing the bill or not. As it stands, we are of the view that that bill, as signed and enacted into law, is unconstitutional. It's flawed in a number of respects, and we are therefore morally and ethically bound, I believe, to challenge that law. We need to challenge the law on the basis of getting the law constitutional, because we cannot just sit back and be party to unconstitutional law if everything in us tells us it's unconstitutional. All our opinions tell us it's unconstitutional. So we are looking at, we are briefing and discussing with our legal teams what to do now. But looks like we will be challenging it in the Constitutional Court, but we want to do so in a constructive way and in a way that does put the election in 2024 in jeopardy.
Now, of course, the IEC having said that it would probably, this was, of course, after that Constitutional Court judgment, after government was given 24 months and, the National Assembly was given 24 months to amend the bill. The IEC, rather, did say it would need about 18 months to prepare for elections from after the bill has been sorted out. The bill being signed yesterday, if we are to vote in May, which is usually when we vote, it gives them just 12 months to prepare. And now there is your organization and many others that are saying they will challenge the signing into law of the bill at the Constitutional Court. So maybe South Africans won't vote in May then. It might delay the elections.
Well, first of all, there is a provision for the election to be delayed by 6 months. So the actual deadline is around August sometime that the election can be held, the outer limit of when the election can be held. But it is seriously flawed. And let me give you an example of one of the problems. And this is, in fact, the area that we will be honing in on. And that is an independent candidate can, for example, you said it's going to be difficult for you to stand. Let me show you how difficult it will be. For independent candidates, that independent candidate may stand in all 9 provinces, but cannot add the votes together. So say now you get 10,000 votes in each of the provinces. You've got 90,000 votes behind your name. You need about 45,000 votes to be elected. But because you cannot add the votes together, you are out. Whereas a political party who may get exactly the same distribution of votes across the country, because they can add their votes together, means that they could get around 2 or maybe even 3 members of parliament in on the proportional list. So you see, the equation for independent candidates and the equation for party candidates are not equal, and we believe that goes completely against the equality clause of the Constitution.
So there's an issue then, Mr. Swanepoel, if you can correct me if I'm wrong, there's a bit of an issue then with South Africa's electoral system as a whole.
Yes, well, I mean, at the end of the day, this is an interim measure that is being dealt with in line with the Constitutional Court judgment, which said that independent candidates need to be accommodated to stand for national and provincial elections. But we are seeking to many in civil society, and I believe in the political establishment as well. We are seeking much broader reform. We are looking for a system which combines constituency elections, some form of constituency election with proportionality. But that broader reform is impossible to complete before the 2024 election. So we have agreed that we follow a two-step approach where we allow for independent candidates to be accommodated for the 2024 election with broader electoral reform for 2029. But that agreement is sufficed on the basis of the law being constitutional. And we believe it is not. I must say that there is a real intention to look at broader reform for 2029, in the electoral bill that has been approved is something we welcome, is the establishment of an independent panel to develop proposals for the for broader electoral reform proposals for the 2029 election.
Maybe the first thing they should do is allow the independent candidate to, combine all his or her numbers, because that's what political parties do in order to get to the National Assembly, right?
Exactly. I mean, and we have made proposals to the Portfolio Committee in Parliament, to the Select Committee in Parliament. We have sent it through to the Presidency as to how it can be corrected, how the law could be corrected to allow for that aggregation to take place. But it seems that it did not find favour, and now we are situation where we have to challenge it, which we do not want to do. This is not something we want to do. We believe it's very important to hold elections, quality, sound elections on time and timelessly. So we don't want to take it to the Constitutional Court, but we are not the cause for that. It's the process. It was delayed. I mean, they had 2 years to start this process. They only started way more than a year. They allowed just to stand idle before they started the process.
Politics of power and the numbers game. That's how it works for the moment in South Africa. Thank you very much for speaking to us. That was Daryl Swanepoel. He is the CEO of the Inclusive Society Institute, and he says they have gotten some advice from their legal team to probably go and challenge the signing into law of the Electoral Amendment Bill that the President Cyril Ramaphosa announced he signed yesterday.